Hello, I'm Jane Fielding, head of the Employment, Labour and Equalities team here in Gowling in the UK, and I'm delighted to welcome you to this, which is the fourth and last of our webinars, which we've been running over the last couple of weeks to replace our usual in-person seminar in our offices. Those of you who've been to the last three of these will have heard me say each time I very much hope that in June, when we do our mid-year review, we'll be able to welcome you back in person. And you may have thought I've been too optimistic. But with the news yesterday about the AstraZeneca vaccine potentially stopping the spread as well as giving immunity, then I am staying optimistic and very much hope to see you there. But today's topic is taking tough decisions in tough times. And in this context, we mean dealing with senior executive exits. When everything else is uncertain, it's tempting in an organisation to stick with the security of what you know and the status quo, but that doesn't always give an organisation the leadership that it needs, particularly in challenging times, and that can lead to these sorts of difficult decisions. So our speaker today is my friend and partner Jonathan Chamberlain, who's going to bring his wealth of experience over many years of helping boardrooms deal with this sort of situation. He's going to share his tips on how best to approach it, identify some trends that we're seeing in how these situations are being dealt with, and he's also going to identify how COVID may be affecting how we might deal with these situations differently. This webinar is a little bit different from the previous three. There aren't going to be any slides other than this introduction one, and there are not going to be any notes. So if you do want to take notes as you go along, then please do. We're also going to take questions throughout the session, as well as at the end. So if you do want to ask something, please use the Q&A function, which you'll find as usual in the middle of the bottom of your Zoom screen. I'll be keeping an eye on those as Jonathan talks, and we'll feed those in at appropriate times when he pauses for breath. And if you've got any technical problems, hopefully there won't be any, but if you do, then please use that Q&A function to ask about those as well. And Lucy Strong, who is helping us with the tech, will do her best to sort you out with those. And I will now hand over to Jonathan.
Thanks, Jane. Good morning. Thank you very much for joining. You might have not done a senior executive exit before. You might have done dozens. Looking at the attendance list for this session this morning, there are some of you who have done at least as many of these as I have, but don't worry. There is something for everyone. Indeed, I hope this will all be for everyone as we go through this morning. And what I need to do is talk about three things. Firstly, I'm going to talk about, as Jane has mentioned, what difference do we think that COVID is making to these sorts of scenarios at the moment? I'm going straight in with that. That's going to be the first thing we're going to have. This session is not like EastEnders. I don't have to build up to the duffs. I can give you the good stuff straight away. Then we're going to go back to basics for a bit, just remind ourselves of the principles or the key principles, the legal principles that apply, key economic principles that apply in negotiating a senior exit. Now, if you've done lots of these before, that might be the point that you want to check your emails, you want to minimize me into the top corner or have me on your second screen. That's fine, you carry on. I will bring you back for the third part, which is talking about how we deal with discretionary bonuses and discretions in relation to share schemes, because the law on that has changed in 2015. I want to talk about how we got there and what difference that is making in practice since. And I think that's still a very confused situation. I think it's worthwhile everyone tuning in for that bit. So, as Jane has said, I'm not going to use slides for this. Okay, this is you and me having a coffee, talking about stuff. That's how we're going to do it. Okay. So, firstly, I said, how is COVID making a difference? And I had a chat with a friend who acts mainly for employees. Obviously, we act mainly for employers. And I said, how do you think it's making a difference? And he said, well, I don't think it's making a difference at all. He said, apart from mitigation. And I thought that's a bit, apart from that, Mrs. Lincoln, how did you enjoy the play? because that is pretty crucial. But it's not the only area where COVID is making a difference. I think there are 3 others as well. And there's one that's actually quite helpful for employees. There's one that makes it more difficult for both employees and employers. And there's one that certainly makes it more difficult for employees. And they are, I'm going to cover these in a bit more detail in a second, that the tribunal system is completely clogged up, that the formalities of exit, not the formalities, the mechanics of exit are perhaps easier now we're all working remotely, but also COVID and this way of working is making a lot of things a lot harder, and that is having an impact on how these things are dealt with and managed. So let's just turn to the first of those, mitigation. As we're going to remind ourselves in a couple of minutes, the starting point for the calculation of loss in relation to a senior executive is their contract. If you're a senior executive, perhaps I should have started with definitions. Lawyers always like to start with definitions, and that's perhaps why I've just kept away from them to a little bit different. But what do we mean by senior executive in this context? I think it's somebody with a 6, 12-month, 18-month notice period. I don't see many of those nowadays, but someone with a long notice period, where the value for them on exit, where they're going to generate most cash, is in the contract rather than necessarily in their statutory employment protection rights, or their right not to be unfairly dismissed. Discrimination is another thing, we'll come on to that in a moment. But we're talking about people with long notice periods, and of course they are under a duty to mitigate, and that means they're under a duty to go and look for another job, and it is harder to find another job in this climate, which means that if you're negotiating the contract and you're saying, well, you're on a 12-month notice, but we're only going to offer to pay you 6 because you'll easily get another job in 3, they can turn around quite legitimately and say, in this climate, are you kidding? And that means that the price of exits is going to go up, because it's quite hard to argue against that. And that's a big point, because mitigation is normally the technical subject of discussion. It's not the only pressure or negotiating lever that one might have, but it is the heart of the legal principles that apply on negotiating damages for a contract of employment. If that then points towards higher settlements, something that points towards lower settlements are the state of the tribunals. Because although the employment tribunal may not be the forum for recovering most of your loss if you don't do a deal as a senior executive, because compensation for unfair dismissal is capped, and that cap may be smaller than the value of your contract, and you might therefore want to litigate in the High Court. What executives have been able to do until relatively recent, well, this last year, is push forward an employment tribunal claim, specifically reserve their High Court damages claim as a way of putting pressure on the organisation, not necessarily in terms of cash, but to get people involved in it, focused on it, having to do witness statements, go over this stuff. Well, now that pressure is still there because the process is still there, but hearing dates are being pushed so far back. The latest tribunal statistics indicate that claims are up about 13% year on year. So what's going in is up 13%, but what's coming out in terms of hearings is down by about 40%. So, I mean, you know, there are 3 kinds of lawyers, as one of my partners put it, those who can count and those who can't. But you don't have to be any good at maths to realize that that means the system is getting bunged up. And when you realize that, unlike most of us, we are working remotely from home, the employment tribunals systems don't allow the staff to work remotely from home. They have to come in, which means they've been badly hit by COVID, by shielding, and claims that go into the tribunal are taking weeks before they come out, and then months and months before they're listed. So that COVID is making a difference. The threat of the employment tribunal is still there, but it's a long way in the future. One point that we have noticed that actually helps employers is how to conduct one of these exits with dignity, because physically that was often quite difficult to do. If you're telling somebody you're leaving now, this is your last day, your last moment in the organization, where do you tell them? In their office with everyone else around? When do you tell them? On a Monday morning, last thing on a Friday? Because the key point about dignities, both theirs and their colleagues, is no one will ultimately forgive you for the walk of shame. Okay, the office knows when someone's just been fired. They just do. I don't know what the signals are, but they trust me on this. They do, and no one likes that sort of sideways glance, not wanting to meet someone's eyes. It's just horrible. It's humiliating. So what we've always advised, catch somebody on their way in, go to a meeting room before they get to the floor. Now we're working remotely, of course. We don't have to do that. You can do this over Zoom. And once upon a time, that would have been thought of as brutal. You can't do this remotely. You have to do it in person. Well, now it's the way we operate. So there is that. You don't have to meet with somebody in the same room to terminate their employment, and in some ways it's a lot easier now that you don't. But the final thing I wanted to bring up here in this section was the circumstances in which we're all working, in which we're all living at the moment, are making everything hard. It's already stressful, losing your job, and we've talked about mitigation, prospects for other employment. It's actually quite stressful having to fire someone. And both the person doing the firing and the person being fired are already under a tremendous amount of stress. And it's stress that we have all absorbed because we have to, because life has to carry on. But I think many of us will be able to say that there have been times when we've lost our temper with the family, or we haven't been able to sleep, or anything like that, where it actually comes through. It is there in our subconscious, and it comes out in this situation. There's more aggression, there's more fear, and the process has become just that little bit harder to manage. The machinery remains the same, but we're lacking a bit of lubricant in keeping the wheels turning. And I think it just does us all good all to be aware of that. This is going to be hard. It's going to feel harder. It's going to feel more difficult. That's okay. That is, this awful phrase, the new normal. So that's how I think. Jane, sorry.
Yeah, there's a question here around that point you just made about the state of fear, but tied into mitigation. Does it depend partly at the moment on the sector, how somebody might feel about their ability to go and get something else? Because while retail is clearly very difficult, there are other sectors that are more buoyant.
I think it does, and I think it's important to note that there are two parts of that. One is objective reality. Healthcare is doing very well, for example. Data centers are very, very buoyant. Professional services seem to be okay. So in those sectors, you can say, nope, you'll easily be able to mitigate your loss. But it doesn't necessarily feel like it. That general clouding of the judgment, that general inchoate sense of existential terror, if it's not to put it too dramatically, but we live in a world where if you see somebody coming down the street, you find yourself doing this sort of mental maths, like David Beckham about to pass a football. When am I going to be able to pass them without stepping into the road and getting run over? And if that's your constant way of working, even though people might not have as much to fear, they may well feel like it. So if that's how COVID is making a difference, it's making a difference in mitigation, some sectors more than others. The tribunals are clogged up. So it's not much of a threat to employees to say they're going to go to one. It's easier to terminate the physical mechanics of it, but the general state of fear makes negotiations harder. Let's now just recap on some of the basics, if we May. So if you're an old hand at this, check your emails for 5 minutes. What I want to cover here, I want to talk again about some of the mechanics of exit, general principles for calculating damages, which are going to form the starting point of negotiations, how we value benefits in that. We're going to deal with bonus later, what the crossover with employment tribunal compensation is, and the different basis for calculation in the employment tribunal, because I do think that's relevant. And these are the sort of the bits that always turn up when we're having these discussions. So first, talking about mechanics of exit. Nowadays, it's very rare for the Alan Sugar moment. You're fired. Okay, used to happen a lot, doesn't anymore. It's now more of, we're going to put you on garden leave whilst we work out an exit package. And I would encourage that, because you get to keep control. If they're your employee, you can give them some instructions. If not to do things, then not to do things. Don't talk to clients, don't talk to colleagues, and they're still bound by the contract of employment. So ultimately, those instructions can be backed up by court order if necessary. Now, you might need to check your contract to see that you can put somebody on garden leave at any time, as opposed to only being able to put them on garden leave once you've given notice, because otherwise you do have to have a you're fired conversation, but it goes along the lines of, we are now giving you notice of 12 months to terminate your employment and putting you on garden leave. And it would be preferable not to give people notice, because the giving of notice can be quite a useful escalation in negotiations. Not a lot of money, but it's a psychological thing. So we'd like you to go home now, and we're going to be working out an exit package over the next couple of weeks, but you're on garden leave. And if things are getting sticky after a couple of weeks, you can say, we're now going to give you notice. We're going to convert your fixed asset into a wasting one. So the clock starts ticking and they start losing something. And you've got that means of gradual escalation, just turning up the heat a little bit. But if you can't put someone on garden leave unless you've put them on notice, then you've got a tricky call there. Because if you try to say to somebody, you're on garden leave and you have no contractual power, could that be constructive dismissal? Might they then walk away completely and all the restrictive covenants and things fall away and you lose control, and you don't want that? I think that you've probably got a few days without an express garden leave clause, without a material risk of terminating the contract, but you've got no more than a few days. So just check the contract there to see you've got that means of escalation. Sorry, Jane.
Before you carry on, sorry. There's a comment here and a question. So the comment is going back to the point you were making about doing things by Zoom, that Zoom culture can feed into a sense of distance, and sometimes people can forget it's a real person on the screen. So getting empathy on a Zoom call can be difficult, which I think is a very valid comment. The question though is, as you've started to talk about the actual mechanics and having the conversation, what's your view on whether it's worth doing that for somebody very senior as a pre-termination of employment conversation, so a protected conversation? Do you think it's worth it to do it that way?
I think not, generally, because as we know, pre-termination conversations don't apply to discrimination. And if you're only talking about protecting yourself against the risk of unfair dismissal, which, as we'll come on to in a moment, is not that material in cash terms in this context, then why would you bother? You've set up this slightly artificial situation. And to go back to the point that somebody's made about connection on Zoom, this is about authenticity, which always eases communication. And if we're going through this sort of elaborate ritual, this is a protected conversation. And if you don't do this, come on, you're firing me. You know, we've already made things a little bit harder. So my instinct says no, but it depends on the particular circumstances.
Yeah, and I suppose there's the value if you do it that way, that if they go to tribunal on discrimination and they lose, so you're back to unfair dismissal, you can still protect those internal conversations around planning for the conversation, although of course by the time you get to the point that they've lost a discrimination claim, all of that's been aired in the tribunal.
It's been aired in the tribunal anyway. Yes.
It's a call. There's another question actually, what happens if you put somebody on garden leave whilst you look to work out the exit, and while they're on garden leave the timing ticks over the 2 years employment that they get the unfair dismissal rights?
Well, as we're going to come on to in a moment, the unfair dismissal rights may well not be all that significant in this context, but clearly that's something to be taken into account. I mean, there are other circumstances when you've got to let somebody go immediately. You might choose to, because under your payment in lieu of notice clause, you can terminate them by just making a payment of basic salary, as opposed to benefits, which might be quite substantial over the length of those period. And the wording of the contract may be such that it's better for you to do it that way. You are going to have to dive into the detail of the contract here. The contract is a very important document in a way it isn't necessarily in the unfair dismissal claims. Perhaps that's a good point to then just looking at the time here to move over to the calculation of compensation, because, and I'll run both points together, what somebody is entitled to in respect of a breach of contract, that is an early termination of the contract, is calculated differently from what they'd be entitled to if they'd been unfairly dismissed. The test in contract is what they would have received had the contract been properly performed. In other words, if there's a 12-month notice period, I would have stayed for 12 months. I would have got everything I would have got in the next 12 months. Now, as we'll see in a moment, they might not have got a bonus, or they might be in a bonus scheme or a share scheme, but the company has certain discretions which it can choose to exercise or not, and we'll look at those in a moment. But you're looking there at what is the language of the relevant documents. For statutory compensation, whether it's for unfair dismissal or for discrimination, actually, that the measure is what is just and equitable. So the tribunal takes what you might call a more holistic view of what the employee might recover, and they're not limited by the notice period. Now, if you've lost your job here, you're not going to get another job at this level for 3 years, never mind it's a 1-year contract. And never mind that the bonus is expressed to be entirely discretionary, or whether you get shares is at the whim of a parent company many thousands of miles away. Ordinarily, had you stayed in the job and had you not been discriminated against or unfairly dismissed, you would have got this. So we're going to compensate you for it. They don't look at the strict contractual processes. Now, for unfair dismissal, with the cap on compensation, it is really quite rare for a senior executive on a 12-month notice period to be compensated for unfair dismissal as of right. On top of that, frequently it will be used in negotiation. It will be used as a way of paying somebody a bit more than their notice period in order to get the deal done. But it is very, very rare for a senior executive to bring an unfair dismissal claim. I've been doing this for 30 years, almost never seen it. Because it's rarely worth it for them. Discrimination, another thing entirely, because discrimination, you'd be arguing for a multiple of your annual compensation, not a part of it. Where the unfair dismissal compensation is used in the negotiations is if you've got something like a pylon I mentioned a moment ago, where it's salary only for 12 months. They say, oh yes, but had I been unfairly dismissed, if I am unfairly dismissed, had I been in tribunal, then I can bring in the value of the benefits there, because under the just and equitable heading. So a pylon may not save you as much money as you might think. How do the two interrelate? This is always an extraordinarily complex question, but the way it works is this: you total up the loss, and then the tribunal applies the cap. So if someone is out of work, likely to be out of work for 12 months, and they're on a 12-month contract and you've paid them out for a 12-month contract, a tribunal is not going to give them any more money materially for unfair dismissal, might do for discrimination. because it's not going to look more than 12 months out. But if the tribunal says you're going to be out of work for 3 years and you've paid them 12 months money, the tribunal will say, well, there's another 2 years of loss. We can actually only compensate part of that because there are caps, but that's how it will be applied. This is really complicated. It's second nature to us as English employment lawyers, but when we have these conversations with our still, we call them our friends on the other side of the English Channel, whose employment laws are notoriously much more onerous, the mechanisms for enforcement are so much more straightforward. I mean, wrongful dismissal and unfair dismissal. Try explaining the difference in concepts and having to enforce it in different courts. People will just be baffled, and rightly so. This is complicated. Right. So now, if you had me in the corner for a bit, or on your second screen, you're doing your emails, now might be a good time to come back in, because we're going to talk about bonuses and share schemes, and what I still call the new law, although this all stems out of a decision in 2015, which wasn't about bonuses or share schemes. It was about life assurance and the most unfortunate Mr. Braganza, who went overboard at night off a British registered tanker belonging to BP. And the question for the employer was, did he commit suicide, in which case they didn't have to pay out under life assurance, or did he not, in which case they did. They had a discretion as to their view of the facts. And the case went all the way to the Supreme Court, and it was about how employers take a decision in circumstances where they have a conflict of interest, because clearly BP doesn't want to have to pay out the life insurance in those circumstances. So it's self-insured. So and the Supreme Court recognised, and indeed mentioned in the decision, that this was going to have an impact on discretionary bonuses, because, and it particularly comes into play on termination. You remember we said a moment ago, you're looking at what they would have received over the 12 months. Well, they might have received a bonus. The bonus will be expressed to be, what's often expressed to be, discretionary. Sometimes it's targets. If you hit targets, then this is what you get. It's a formula, but even the formulas tend to include an element of discretion, either as to whether you get it all or whether you get part, depending on our assessment of your performance, etc., etc. And this language has been around for a long time, and up until the sort of late 90s, early 2000s, there was an arms race, effectively, in the City of London between the lawyers who were drafting these contracts and the lawyers who were acting for the traders and the bankers who had been fired, the bulk of whose remuneration came in bonus and wanted to get their hands on it. And the language would say, this bonus is entirely in our discretion, and we can pay you if we feel like it, and not pay you if we don't feel like it, depending on the weather and the colour of our socks this morning, and that's all fine. And the employees would be saying, no, that can't be what the language means if I've performed really highly. And where it ultimately got to was this concept of a series of decisions, Clark and Nomura and the Dresden Bank case, where the only fetter on the employer's discretion was rationality. Was it an irrational decision not to pay the bonus? That changed under Braganza, because as well as irrationality, there was brought in a procedural element. And it was a straight read across from public law concepts that apply to local councils when they take decisions. Have they taken into account factors which they should not have taken into account? Have they taken into account all the factors they should have taken into account? And then, was the decision so irrational that no employer in similar circumstances would have taken it? So it's that procedural element that's coming. Now, the court recognised that applying that sort of test by a judge to a decision taken by an employer is really hard. And they said they don't want to go down that route. They said it's much more amenable to as in the case of Braganza, literally life or death decisions, one-offs, did this fact happen? Did this fact not happen? Not when you get into questions of subjectivity around performance. And the judges themselves have said they find this really hard to apply in practice. But let me give you one illustration of where it has worked in practice, which was a bonus decision for a very substantial company, where the company knew that they got this risk, and so they followed very careful, very thorough legal advice on things they should take into account, things they should not take into account, and came up with their decision that the exiting executive was not going to be a good leaver for the purposes of the remuneration of the bonus scheme. They were going to be a bad leaver, terms very often used. And he made the argument that, look, you've taken into these things into account, that I wasn't up to my job, that I wasn't very collegiate, but you never heard my version of events. You never asked me. These are all subjective things. I have a view on this. I have more information to give you. That is a factor which you have not taken into account, and you should have taken into account. The employer had applied for the case to be struck out on a summary basis, and the judge wouldn't do it. The judge said, it's got a point. We need to hear about that properly in full court. Now, the case was settled before it ever got to that. But what became clear there was that it's not as simple for employers anymore. So we are used in negotiating these settlements to being able to say, discretionary bonus, not an irrational decision, you don't get it. Now, we're going to have to show our working out. And that working out may well include hearing from the departing employee. Again, so much is going to come down to the wording of the particular scheme and the particular circumstances in which you find yourself. It may be that there are factors here which means that it doesn't really matter what the employee says, and so their view is not something which you should take into account. But it's not as simple as it used to be. And that's the thing that I want to leave you with, because I think that is really the whole theme of today in the environment in which we found ourselves. These things are not quite as easy as they used to be. Right, I'm going to pause there, Jane, see if we've got any more questions. I can see a little red number on my Q&A thing, which indicates that there are some.
We do indeed have questions, yes. So there's a couple on garden leave, which I'll come back to in a minute. But first of all, I thought it'd be helpful to highlight a comment we've had from somebody we both know well, rather than a question. So saying that they find it helpful to bring up outplacement counselling very early on in the conversation to try to get people focused on the future, that there is a future. And it helps obviously with mitigation, and then allied to that, using a sort of structured settlement which incentivizes them financially to find something earlier, and it limits the long-term exposure for the company, which is something that we do as well, don't we?
Yes, that's right. And there are ways that you can split this. So you can pay people on the drip, and then say you will have half of the balance of your notice period, for example, when you get another job, which means that clearly the earlier they get it, the more ultimately they get. It'll work out roughly the same amount of money if they're out of work for the whole 12 months, but it does mean they get a chance of a bonus, as it were, something more than their actual loss. Yeah.
And then the two questions on garden leave, if we take those together. One is, you talked about putting people on garden leave before giving notice if the contract allows you to do that. Is there some standard contract wording to achieve that? And the second one is clarifying using garden leave. Is it actually better, because that's what this organisation does, is to talk about paid leave while you're negotiating and then put them on garden leave? Or does it not really matter?
Garden leave isn't really a term of art. What garden leave means is we're still paying you, but you're not working for us and you're not working for anyone else. how you label that goes back to a point that's already been made by me and by you, which is do this sensitively. And I think that's what the questioner here is also saying. Garden leave might have pejorative connotations. We put you on garden leave because you don't want to go to a competitor. We put you on garden leave because we're putting you out to grass. If you want to say we're just going to ask you to go on leave, or even not label it, just don't come into the office, don't, a series of negatives rather than an actual label. The point about standard wording, well, there is standard wording in this sense. The garden leave clause in the contract says we can at any time choose to ask you or to require you not to attend the office, not to perform any duties, not to contact clients, customers, colleagues, provided that we pay you whatever it is we pay you under the contract. Contrast that with a clause that begins, during any period of notice, whether given by you or the company may require you to remain at home, not contact colleagues, etc., etc., etc. And we see both clauses. And if you're negotiating one of these things for a senior executive, you are a senior executive. You may well want to say, I only want to be on garden leave whilst I'm on notice. But both used, both are in circulation. Check the contract before you do it. The key thing is, don't put someone on garden leave in circumstances where you're not entitled to put them on garden leave, because although they are unlikely to turn around and go, aha, gotcha, constructive dismissal, in these circumstances, it's not helpful for them to do that. They might, and remember everything we've said, there's a lot of irrationality, there's a lot of fear around this. That sort of detail is important to get right. You need to demonstrate you have a grip on this process. That's really important if you're going to get a successful resolution.
Okay. And then we've obviously got a number of attendees from publicly listed companies. Can you give any guidance on what different approach they may need to take, whether there's any extra requirements or steps?
Well, I think the point to note here is that the way the rules are now worded, and have been for many years, this is not new, is that if you take somebody out of the active management of the company, then you have to announce. So for these purposes, garden leave is as good as termination. If you want to announce a deal, so-and-so has agreed to step down, you're going to have to do that deal at a time the market is closed. So between Friday and Monday, because otherwise you have to tell the market. Now, there are, as you might imagine, different views on this. People can be ill, can't they? So does the market really need to know if someone's out of commission for a few days? My view is yeah, because this is different from the random nature of illness. This is the company has decided to make a change in management, and that is something about which investors ought to know. That's not necessarily a universal practice, but garden leave in these circumstances is useful for all the reasons that we've been discussing, but the point to note is it doesn't necessarily get you out of the duty to make an announcement.
Yeah, okay, so we are just about out of time now. There are a few questions that we didn't quite get to, but we will follow up with you afterwards if you're one of those people, so you will get an answer. Otherwise, I will say thank you to Jonathan for the presentation and the Q&A, and thank you to all of you for joining us again today. You will get a request for feedback pop up in your internet browser at some point later this morning. If you do have the time to complete that and send it back to us, that would be great. We do read them and we do take them into account for future sessions in June and in between. So thank you very much and enjoy the rest of your day.
Thanks, everyone. Thanks, Jane.